Getting into exceptions to prior art, disclosures made a year or less before the effective filing date of the claimed invention. Again, we're talking about a disclosure during the grace period. And the subject matter disclosed had, before such disclosure, been publicly disclosed by the inventor or a joint inventor, or another who obtained the subject matter disclosed directly or indirectly. So, for this exception to apply to a third party's disclosure of the subject matter, first, it must be made during the grace period. Any inventor-originated disclosure must have been made prior to the third party's disclosure. Both must have disclosed the same subject matter. We'll get to some definitions here. Another, somebody who discloses subject matter that was obtained directly or indirectly from one or more members of the inventive entity. And a third party, someone who disclosed subject matter but did not obtain it directly or indirectly from a member of the inventive entity. Just a little definition there. Okay, Al, Bob, and Cy claimed an invention with an effective filing date of May 1st, 2015. Here's your May 1st, 2014, so this is your grace period. Al, Bob, and Cy disclosed the subject matter during the grace period, and the third party, Ty, discloses the subject matter within the grace period and after Al, Bob, and Cy. So, this third-party disclosure is not prior art, based on the exception to 102A1. And we know again that Al, Bob, and Cy's disclosure is not prior art, based on the disclosure being made during the grace period. Let's look at some more examples. Again, in each of these examples, we have the same May 1st effective filing date 2015 and the same inventors, Al, Bob, and Cy. Also, in each of these examples, a third party, Ty, discloses the subject matter. The assumption here is that Ty did not obtain the subject matter either directly or indirectly from any of the inventors. That being the case, the first one, Bob discloses subject matter, third party discloses subject matter, and all occurs within the grace period. What we're going to concentrate here for these examples is whether or not this third party disclosure would be part of the prior art exception, meaning it would not prevent patenting due to a disclosure. In the first case, of course not. Bob discloses the subject matter first. A third party, who we are going to assume did not get the information from the inventors, discloses. It's within the grace period, no problem. Now, you have D, who obtained from Bob and discloses the subject matter. D obtained it from Bob, one of the inventors, so it would be taken into consideration. However, it's occurring within this grace period. So the answer again here is this third-party disclosure does not matter. Now, here, Bob discloses the subject matter prior to the grace period. So, in this case, again, the third-party disclosure does not matter because Bob has already blown it by making his disclosure outside the grace period. Shielding the claimed invention. When the 102(b)(1)(b) exception applies, the inventor's prior public disclosure of subject matter X acts as a shield. It shields the claimed invention from a prior art rejection based on the third party's intervening disclosure of subject matter. Again here, this must occur within the grace period. Mode of disclosure. Although the same subject matter must be disclosed in order for there to be a disclosure, there is no requirement that the inventor-originated disclosure and the intervening disclosure be made in the same manner, meaning the inventor might have displayed the invention at a trade show, and the third party's disclosure may be a newspaper article about the inventor disclosing the invention at the trade show. Nor do they have to use identical words, figures, or other forms of expression. Obviousness does not equal same subject matter, and that's an important point to understand. Even if an intervening disclosure by a third party is obvious over an inventor-originated prior public disclosure, this is not a disclosure of the same subject matter. So the exception isn't going to apply here. Important. Only the portion of the third party's intervening disclosure that was previously in an inventor-originated disclosure, remember we're talking about shielding here, is unavailable as prior art when this exception applies. So you can't just have the inventors disclosing one part and the third party disclosing parts 1, 2, and 3 and have this shield apply. In other words, the claimed invention is not shielded from that portion of the third party's disclosure. Now remember, patents are judged claim by claim, so you would have the prior art issue with respect to this portion. Here's a chart that could be very helpful for you in studying or answering questions on the exam. Again, because of all the information that is here, this is one of the reasons why I've asked you to have the printouts of the slides available during this lecture. So, let's walk through this. Inventor's public disclosure. A flathead screw. Third party. General category that includes the screw. Does the inventor's prior public disclosure act as a shield? Yes, rejection can be based on third parties' disclosure of just a general category. Inventor discloses a flat-headed screw again. The third party's intervening disclosure lists a species that includes X. For example, a flat-headed screw, a Phillips-headed screw, a hex-headed screw, etc. Partially. It can act as a shield partially. Rejection can be based on the third party's disclosure of other species, but not on the disclosure of X. Finally, inventor's prior public disclosure is a general category, screws. And the third party, a species within the general category of screws, such as a flat-headed screw. Does this shield protect? No. Rejection can be based on third parties' disclosure of the species. Moving on. Some more examples. Inventor's public disclosure, X, which is, say, methyl. Intervening disclosure, general category, for example, alkyl. Is it shielding? Yes. Again, rejection cannot be based on third parties' disclosure of a general category that includes X. Again, X is methyl. A list of species that includes X. Methyl, ethyl, propyl, etc. Partially. Rejection can be based on third parties' disclosure of other species, but not on the disclosure of X. General category, alkyl. Third party, species X. Shield apply? No. Rejection can be based on third parties' disclosure of the species. Just touching on patent documents and the statutory language. A U.S. patent issued under Section 151, U.S. patent application for patent that is published under Section 122B, and a WIPO published PCT international application that designates the United States. And that's application for patent that is deemed published 122B C35 USC 374. Take-home message here is that foreign patent documents, for example, Japanese or Great Britain published applications, cannot be prior art as of their filing date under 102A2. However, they may be printed publication prior art under 102A1. So you always have to look at events because it might be shielded by one, but then come back and hit you through another. So only U.S. patent documents can be applied under 102A2. Let me make a statement here. I'm not going to go down to the nitty-gritty of the sections and subsections in an exam. I'm just going to talk about a 102 rejection. Use the exceptions, so forth, to answer the question, but you're not going to have to give the specific section, subsection, subsection. Here we have an effective filing date of all of our inventors. D files a French publication. I'm sorry, a French application which is published. No, it's not a U.S. patent document, so it can't be applied. D files a Japanese application which is later published, which claims priority to a U.S. provisional application. No, it's the publication doesn't fall under 102A2. D files a U.S. application which is never published and is eventually abandoned. If you file an application which is never published and eventually is abandoned, it will not be prior art. Why? Because it's not a disclosure to the public. So a WIPO published PCT application, foreign, must have designated the U.S. in order to be a 102A2 prior art. So if you're filing a PCT that is just for Germany and France, doesn't designate the U.S., no problem. However, PCT applications filed on or after January 1st, 2004 automatically designate the United States. So the issue here is that whether or not it designates it specifically, it will automatically designate the United States. There is no requirement that a published PCT application have been filed on or after November 29th, 2000, or have been published in English. This is a distinction from pre-AIA. So it does not have to be published in English. Thank you.